Welcome, everyone. It's great to have you all here at this 4IP Council's webinar called Plausibility from Herbicides to Insecticides and Beyond. My name is Axel Frazzini. I'm the Managing Director of 4IP Council, and I'll be your host today. As you may know, 4IP Council is a not-for-profit organization, and we are focused on the link between IP and innovation. Our mission is to identify the most relevant topics and produce empirical research by collaborating with a wide variety of academics, experts, IP organizations, and other stakeholders. On our website, 4ipcouncil.eu, you can find plenty of free materials. For example, studies, summaries of relevant papers, recordings of our webinars, such as this one, the podcast interviews, and now we are featuring a sustainability special in the podcast. So I invite you to check it out. We also produce easy to digest content at the 4, like the number 4, SME Corner, especially tailored for non-IP experts, the startups, and the SMEs. We also have a brand new area on our website that is called IoT and Cellular Standards Made Simple, where you can learn about the benefits of standards and IoT across different sectors. I invite you to review it. And if you find anything that you would like to comment, please contact us. You can also follow us on X, formerly Twitter, on LinkedIn, on YouTube, on Instagram. Our handle is always at 4IP Council. There you can find about the latest news, the resources, interviews, as well as the future webinars. But without further delay, it is really my pleasure today to introduce our speakers for the webinar, Sir Robin Jacob and Dheemanth Vangimala. Sir Robin Jacob joined the Faculty of Law at UCL in May 2011, leaving the Court of Appeal of England and Wales to do so. Sir Robin was appointed a Law Justice of Appeal in October 2003 and was Treasurer of Gray's Inn in 2007. He continues to sit from time to time in the Court of Appeal and will sometimes act as an arbitrator or a mediator. He has written extensively on all forms of intellectual property. Dheemanth Vangimala graduated from University College London in September 2023 with an LLM in intellectual property law. He is currently working as a research assistant at the Institute of Brand and Innovation Law, IBIL, at UCL, while completing his bar course before he commences pupillage at 3 New Square later this year. Dheemanth won the first place of the 2023 4IP Research Awards, and this webinar is based on his winning paper, Plausibility and the Flotilla. Have the English courts drifted from the Commodore's approach to the evidential requirement for patent validity? And if so, is this divergence justified? You can find this paper on our website just under research. A final remark, you will find a Q&A tool at the bottom of your screen. Please do not hesitate to submit your questions, and right after the presentation, we'll take them, and live answers will be provided by Dheemanth and Sir Robin Jacob. So you can raise your question now or wait until the end, and Dheemanth, the floor is yours.
Thank you very much, Axel. Thank you for inviting me to speak today, and thank you as well to Sir Robin for agreeing to participate in this webinar. As Axel has already introduced, I'm going to be, unsurprisingly, speaking to you about plausibility today, and this talk is based on my paper that I submitted to 4IP for its competition. The structure that I'm going to be taking you through is, as you can see on your screen, essentially the what, why, and how of plausibility. So I'll be starting with what plausibility, what that requirement actually refers to, what does it mean? Then I'll move on to what perceived hole in the patent system that requirement is purported to be aimed at plug-in, and to use a very common law term, essentially, what's the targeted mischief? And finally, I'll be talking to you through how the various decision-making bodies, particularly the EPO and the English courts, have handled the plausibility requirement in some more recent and topical decisions. In terms of what I'll be talking about in the how, I'm going to be really focusing on the degree of proof, how much evidence is actually required. And to put it another way, what is the evidential standard for plausibility as it currently stands? So to kick things off, it's relatively uncontentious to say that the 1995 EPO Agarivo decision is really where the patent law principles that we now recognize as the plausibility requirement first originated. That decision concerned a broad chemical compound that was purported to have herbicidal effects. The board found that this use as herbicides hadn't been made credible by the evidence in the patent application, and consequently, the patent lacked an inventive step and was held to be invalid. Over time, this terminology of credible has morphed into what we now know as plausible or plausibility. But what does it actually mean? What are we asking the patentee to provide? Well, looking through the literature, it's proven relatively tricky to nail down a succinct, all-encompassing one-line definition for the term. And the clearest one that I could find is the one that you can see on your screen that's been provided by Dr. Alison Slade from Leicester University in her seminal paper in 2022 on the subject. It's something that I thoroughly recommend anyone interested in the subject to go and have a read. And what she says, at its most basic level, plausibility is an evidential requirement that asks whether the patent specification demonstrates that the claimed invention's purported technical contribution is achievable. So let's say, hypothetically, I were to have a patent for chemical X, and I were to say it's to be used for the treatment of disease Y. Then my patent application should have something that demonstrates that that is actually achievable, that chemical X can be used for treating disease Y. Now, you won't find anything like credible or plausible in the EPC, in the language of the EPC, or any patent statute for that matter. So the EPO and the courts have had to slide in this requirement under one of the validity criteria, most often under sufficiency or inventive step. But if you were to look at the actual language of what those two requirements require, there isn't anything remotely resembling plausibility. All that's required for inventive step is that the skilled addressee doesn't consider the invention to be obvious. All that's required for sufficiency is that the skilled addressee can read the patent and that it discloses enough to make the invention workable. So this has led some people writing on the subject, such as a particular Sir Robin Jacob, to call the effort of sliding in plausibility into one of these requirements as positively Humpty Dumpty-ish. Essentially, words are what I say they mean, or something along those lines. But there is the justification that's used for doing this is at least what has been argued, is the patent bargain, namely that the patent monopoly should correspond to what's actually been disclosed in the patent application. And that's really the basis under which that unifies these various statutory validity criteria, and then that the EPO and the courts have relied on to slide in plausibility. I won't say much more on that. I'm going to move on to the targeted mischief. I should say right now, I am happy for these slides to be shared, so please don't feel the need to have to read every single word on the slides as I go through. I'm going to be explaining it, and you will have the slides after this. So what is, there is a certain amount of legal gymnastics involved in getting plausibility in. So why do it? What is it that we're aiming, what defect are we aiming to resolve? As Sir Richard Arnold and Sir Christopher Floyd have written about this extrajudicially, and what they say is that speculative patenting is really where plausibility comes into its own. This is sometimes referred to as armchair inventing, which brings to mind this notional person sitting down, watching TV, eating a bucket of popcorn, and then has these novel, non-obvious ideas of some chemical compounds and then files patent applications without doing any experimenting or testing that they actually work. And it's been argued that these armchair inventors aren't really contributing to the stock of technical knowledge, so there is no legal justification to grant them a patent. However, again, some such as Sir Robin have argued that if the invention is non-obvious, if the invention is novel and it's actually workable from the patent application, they are, in fact, contributing to the stock of technical knowledge. So why not grant these armchair inventors, speculative or otherwise, why not grant them a patent? Perhaps this is something we can come back to during the Q&A, but for now, all that needs to be said is that speculative patenting is the route through which is the justification that's usually used to argue that the plausibility requirement is actually needed in our patent system. Another is overly broad claims, and I'm not so, I don't find that particularly convincing. That's less persuasive. And again, that's something we can come back to during the Q&A. Moving on to how the various decision-making bodies have handled plausibility and how they've pitched the evidential requirement. Let's start with the EPO. As I've already touched on, Agarivo is where this first began, and there have been numerous decisions since. And it's been suggested that the evidential standard has varied across numerous decisions, and they fall under two broad camps. The first is ab initio plausibility, and the second is ab initio implausibility. And in order to understand what these terms refer to, it's helpful to look at what the facts were in a case that led to a referral to the enlarged board in G221. That's the case that you can see on your screen. Now, the referral to the enlarged board concerned a patent for a composition of insecticides. The description outlined how that particular composition of insecticides were meant to work synergistically to kill a particular species of moths. The patent was opposed. The opposing party relied on some post-published evidence to demonstrate that the composition didn't have the purported technical effect against that particular species of moths that was detailed in the description. To counter this, the patentee also relied on some post-published evidence that demonstrated that that composition did have a technical effect, but against another species of moths that wasn't detailed in the description. So on the evidential standard, the question that was before the enlarged board in G221 was, can a patentee only rely on a purported technical effect if they've actively provided in the patent application evidence that it works against that particular species of moths? Or could they rely on that technical effect, or rather, would that evidence only be required if the skilled addressee would have substantiated doubts when reading through the patent application? So one evidential standard always imposes a positive obligation on the patentee to provide evidence. The other would only impose such an obligation if there were substantiated doubts on reading the patent. The enlarged board's decision on this point is, to put it bluntly, not very helpful. The board firstly admonished the term plausibility, saying that it's a generic catchword that's been seized on by some decision-making bodies. So we're not allowed to use the term plausibility anymore. Fine. But the board then goes on to provide its own test that it says is a reformulation of the various arguably diverging decisions that preceded it. And many authors have pointed out how this reformulated test that you can see on your screen is ambiguous. To a certain degree, I agree. It doesn't really answer the main question that was put to it. Is there a positive obligation on patentees, or does such an obligation only arise if there is substantiated doubt? Fortunately, G221 was not the last word on this matter. There have been subsequent developments that tell us how to actually interpret it. And in my opinion, the later developments indicate that G221 is saying that it's a substantiated doubt standard going forward. And that is the one that applies in Europe, in my opinion. Why do I say this? Well, there are three reasons. Firstly, we have a handful of technical board decisions that have gone on to allow patents where the evidence for purported technical effects were not found in the application as filed. And these are technical board decisions that came after G221. The clearest reasoning for this is in the technical board decision that came after G221, and this is the board that originally referred the case to the enlarged board in G221. When the case came back to that technical board, they had the unenviable task of having to interpret and apply the enlarged board's decision. And as you can see on this slide, the way that the technical board interprets G221 is that the test is asking whether the skilled addressee would have legitimate reasons to doubt the purported technical effect can be achieved with the claimed subject matter. Only then would positive evidence be required in the application. To me, this is unambiguously the ab initio implausibility in all but name. The party opposing the patent in this case hadn't provided any evidence to suggest that the skilled addressee would have legitimate reasons to doubt that the invention would have the insecticidal effects against the specific species of moths that the patentee was claiming that it would have such effects against in that post-published evidence. So consequently, the opposition failed. The opposing party has since filed a petition for review to the enlarged board, and somewhat hot off the press, the enlarged board published a communication on 17th of May, so a little less than 2 weeks ago, where in their preliminary opinion, they held that the petition was, using their words, clearly unallowable. So I think this is where we're at least as far as the...
Only about 1 in 20 get through, and they don't get through on legal points. There's normally a complaint about some procedural error.
So in this petition, they were arguing that the technical board had violated the right to be heard, and the enlarged board just disagreed. They said the technical board had heard all the evidence that they needed to in formulating their...
They always say that. Basically, they don't do appeals.
So I think this is the direction in which the EPO is heading, the substantiated doubt standard. The second reason why I say this is the way that the national courts have handled G221 since the decision came out. This can be found in a series of cases concerning the patent for apixaban. And so apixaban is an anticoagulant in the treatment of thromboembolic disorders. Essentially, it's a blood thinner used to prevent strokes. And apixaban is something that's relatively close to my heart. Like, I started my medical training around the time that the drug received regulatory approval in the UK. And at that time, NOACs, as they were called, novel oral anticoagulants, were all the buzz amongst hematologists and stroke physicians. And the way NOACs work are by targeting specific proteins in the blood that are responsible for clots forming. And apixaban specifically is responsible for targeting a protein called factor Xa. Now, the patent was for apixaban and for its use in treating thromboembolic disorders. And Sandoz, one of the generics manufacturers, had alleged that the patent hadn't made plausible apixaban's effects as an effective factor Xa inhibitor. Litigation is still ongoing in some jurisdictions, but we have many decisions now on the subject which have weighed in on what G221 should be interpreted as saying. And the one that I want to hone in on is the one from the Netherlands. And this is from the Court of Appeal of The Hague. And an eminent patent judge, Justice Rian Calden, concluded that G221 doesn't always impose a positive obligation on patentees. As a matter of a preliminary decision, Justice Calden had no issue finding that the patent was valid, as Sandoz hadn't provided any evidence that would say that the skilled addressee had any doubts that apixaban could function as an effective factor Xa inhibitor. So again, this is unambiguously, to me, a substantiated doubt standard.
You might know Rian Calden is now the vice president of the Unified Patent Court, who has left the Court of Appeal of The Hague.
Yeah. And
that's a pretty weighty place. This is an opinion from a pretty weighty judge.
So, and if plausibility were to reach the UPC, I think exactly it's quite likely to go this way. Possibly, of course, we have no reason to say one way or another, no guarantee. And similar decisions have been reached in jurisdictions such as France and Norway. However, in the Court of Appeal of England and Wales and in the High Court of Ireland, the decision went the other way. And I'll come on to what's happened in England and Wales shortly. My final reason for landing on the substantiated doubt standard as the way forward in Europe is that arguably there was really no difference, no divergence between the EPO decisions preceding G221. I won't really say any more on this. Rose Hughes, who is a patent attorney who writes a lot of patent material for the IPCAT blog, has written extensively on this particular point. So please do go and have a read over there. And again, happy to discuss it during the Q&A if needed. So what's been going on in the UK? Well, preceding G221, we've had two Supreme Court decisions on the evidential standard for plausibility. The most recent is Warner-Lambert in 2018, and this case concerned a second medical use patent for pregabalin in the use of treating neuropathic pain, amongst other types of pain. And Lyrica, that's Warner-Lambert's branded version of pregabalin, was a blockbuster drug, so it clearly did the job. However, a sufficiency attack was brought against the patent, saying that there was no evidence provided in the patent that pregabalin could actually have this neuropathic pain relieving effect. Lord Sumption, who was in the majority, held that there is a positive obligation on patentees to provide evidence. There must be something provided in the patent that would cause the skilled person to think that there was a reasonable prospect that the assertion would prove to be true. It doesn't necessarily have to be experimental data, but it can't just be an assertion either, according to Lord Sumption and the majority. Contrast that with Lords Mance and Hodge, who felt that this was setting the bar too high, and they landed on something more akin to the substantiated doubt standard, as you can see from that final sentence on the slide. Alas, they were in the minority, so Warner-Lambert is really an authority for the positive obligation standard. And this is, so we have a Supreme Court precedent that says that that is the evidential standard in the UK. It's therefore unsurprising that post G221, things haven't really changed. We in the UK are bound by precedent. So the Court of Appeal and the High Court in the apixaban case had to apply Warner-Lambert. They applied a positive obligation standard and held that the patent was invalid for lack of sufficiency, as it hadn't made the purported effects plausible. It would take another Supreme Court decision to change this. And since then, we've had 3 High Court decisions that you can see on your screen that have had to deal with the plausibility and its evidential standard. And they have quite rightly just applied Warner-Lambert and gone with the positive obligation standard. One thing to note is that there is an appeal pending from a case that preceded G221, Fibrogen and Akebia, that also had to do with plausibility, and there's an appeal pending before the Supreme Court. While plausibility was a live issue in that case, the evidential standard wasn't, but we'll just have to see what actually takes place during the hearing at the Supreme Court when that date comes. So watch this space. Issues, well, in my opinion, there are issues with the UK's stance on the evidential standard for plausibility. Firstly, as the apixaban series of cases have highlighted, there is a potential for the UK to arrive at different conclusions on the same patent to other national courts and possibly even the EPO. I appreciate that this can sometimes come down to the way that the advocates have argued it in front of the relevant courts and what evidence has been put before that particular court. And of course, the UK doesn't necessarily have to follow the same path as other national courts or even the enlarged board for that matter. However, if it is going to diverge, there must be a good justification for doing so. Otherwise, it just doesn't make commercial sense to diverge. So far, I haven't seen a good justification for diversion. Secondly, the positive obligation standard places too much emphasis on the patent bargain, in my opinion. Yes, disclosure is a price a patentee pays for getting a time-limited monopoly. However, there are also forward-looking aspects to what the public gain from patents. Take pharmaceuticals as an example. It's not just the patented compound that the public will gain after it enters the public domain after the patent is expired. It's also all the benefits from all the data from the regulatory approval process, the safety and efficacy trials, optimizing dosages, and so on. Given these forward-looking aspects, the arbitrariness and the inflexibility that I find to be inherent in the positive obligation standard doesn't really benefit the patentee, and in many circumstances, I don't think will even benefit the public because they would be losing out on all these additional benefits. Thirdly, there is, as I said, there are two Supreme Court cases on the evidential standard. One of them is this case that you can see on the screen, which had to do with Neutrokine alpha. And that case arguably supports a substantiated doubt standard over a positive obligation standard. I won't go into the details of the case, just to say that HGS and Eli Lilly is still good law. It hasn't been overturned. It certainly wasn't overturned in Warner-Lambert. In fact, it wasn't cited in that case and hasn't been cited in any subsequent high court case that has had to deal with plausibility and its evidential standard. And I don't know why, other than the fact that Warner-Lambert is a more recent decision, and a decision specifically looking at sufficiency, as opposed to HGS and Eli Lilly, which had to do with industrial applicability. So there is potentially some inconsistency in our own national law about the applicable evidential standard. That's still unresolved. And perhaps this is a way out for us in the UK having to rely on this positive obligation standard. But again, watch the space. In terms of solutions, well, I don't have any. Just a few questions that may help inform the appropriate evidential standard going forward. First, what is the commercial impact of speculative patenting, particularly in the life sciences sector, which is really where plausibility most often arises? Before we continue to adjust and fine-tune the evidential requirement, we really have to have an understanding in empirical terms to what extent this requirement is actually needed. In my humble opinion, a requirement that is based on a patentee having to provide evidence should itself be evidence-based. Secondly, how do other non-EPC jurisdictions deal with speculative patenting if we were to accept that it is actually a problem? I mean, speculative patenting can't just be a European issue. It must be happening elsewhere around the world. And if they're able to tackle it without the need for plausibility, then do we even need it? Or more realistically, do we need such a high standard as a positive obligation? And of course, I am more than open to hear suggestions from the audience, but that's all from me, folks. We're happy to take questions. Thank you very much for your attention.
Thank you so much for this very interesting presentation. So I received 4 comments while you were speaking. First one is, that's very bold from you to write an article on the same topic that Sir Robin wrote 4 years ago. So that's the first thing. Second is, people are 2 people were very impressed of the high quality of your paper. You know, that's a research award that you won at 4IP, and they say, do we need really to be at that level if we want to submit the paper in the future? I would say that this year it was really exceptional. And the 2 other comments were, it seems that the fibrogene case has settled, so there will be no Supreme Court hearing. And that's a comment. Second was HGS was relied on extensively by the Warner-Lambert team in that case, even if not by Supreme Court. Okay. But let's try to just follow up on the fact that Sir Robin, you wrote a paper on this topic, and since then, let's say that some things have changed. So there was this G221 decision and several other national decisions on the matter. Has your opinion changed?
No, not at all. I start slightly further back and say, what's the patent system for? And would the positive obligation promote the patent system, or would it, or the purpose of the patent system, or would it retard it? And you will have seen in my paper, the broadly speaking, I said, well, if a man says compound X will do so and so, and I'm taking out a patent for it, he's got an incentive to find out whether what he said was really true. Well, some would say, well, he hasn't made an invention yet. He's trying to find out whether he's going to. And I say, well, I'm not really interested in philosophy. I'm interested in the practicalities. If the reality is he will test it if he can have a patent, but he won't test it if he won't, then it's not much of a patent system, because it means it will never get tested. And that's true of pretty much all patents are speculative. Obviously, a mechanical device, a new and improved paperclip, you can understand what it is straight away. It's a classical sort of patent. But all these medical patents are basically kind of prospecting licenses. You have a medicine, you administer it to a mouse, the mouse twitches or stops twitching, as the case may be. And you think, oh, I might have some sort of tranquilizer here. That's not a made-up case. That's a true case. It was the first case, that big patent case I was ever in. And there was nothing in the patent about it really working on the mice. It all happened after. And the judge said, well, I noticed that, but never mind, it's a good patent. And the consequence of that patent being upheld was the money kept rolling into SmithKline and French, which enabled them to fund the research for the next big one, which was symmetry. And if you take a sort of theoretical view like Lord Sumption, who once said, well, a barrister should be able to do anything, but I think they should steer clear of intellectual property, but didn't follow his own advice. I think UK law would be in a better state. I am, of course, sympathetic to the view that speculative patenting is in principle a bad thing if it is too grasping. Because once it's too grasping, it becomes implausible, which is the second stand. And if you claim something which is implausible that it will work, that's different. I think that's where the line should be drawn. If it could work, that's good enough. If it's very wide claim, it won't be good enough because it's implausible. And if it's actually implausible, even for a small compound, even then, you have a slight worry about that. Just because a thing's implausible doesn't mean necessarily it's not a good idea. We're talking about the realms of development. And I'd like to see the judges thinking about that. And I'm very glad to see that Rian Calden, who is a very sound judge indeed, has really set the course. And I think the UK would have to give way, and they will. To some extent, Lord Justice Arnold has been somewhat hostile to all this. I think that's a pity.
Okay, very good. It reminds me, Dheemanth, that you talked in the webinar, in the podcast episode that you recorded for IP about the armchair inventing. And I have a question related to this. So you touch on why armchair inventing may not necessarily be a bad thing. Could you expand on this?
Yes, sure. I mean, Sir Robin has already outlined the main point on that on why armchair inventing may not necessarily be a bad thing. And the main reason is that if the invention's obvious, if the invention's not obvious, and if the invention is novel, and it's workable from the application, why does it necessarily matter that it's speculative? Because they've still produced an invention that is contributing to the stock of technical knowledge. And with some smaller R&D initiatives, they sometimes rely on things such as they often rely on grants. They rely on investors and stuff to actually develop said invention. So sometimes they may not necessarily have the funds already to be able to actually take that forward. So why not actually rule them with a patent? And a patent can be quite a useful tool in order to get those.
It's not just small guys. Big guys won't take it forward. They're not going to take it all the way through to clinical trials, costing up to $1 billion more if they can't get a patent. It's just not going to happen.
Okay.
If there was a wonderful world where where research was could be done by universities with huge funding, but the universities aren't going to do it because they're broke. The big pharma will do it. Little pharma won't. Little pharma basically starts off with the ideas, gives them some going, and then sells themselves to big pharma, who then take it forward. No new medicine has entered the market since penicillin in the war without big pharma. Nothing came out of the Soviet Empire. And nothing has yet come from China, but I bet it will, because they believe in the patent system.
And you've also previously made the point, Sir Robin, which if the patent doesn't in fact work, then what's actually lost by granting said patentee a patent? Because it doesn't work, it's not commercially saleable. I suppose the only instance where that may become an issue is where you have patentees who don't necessarily realize that the invention is not a salient invention and use it as a hammer against.
Well, there are such cases as far as I know. I mean, that's again, the economists get excited. Oh, they say, there's lots and lots of patents which are not used. There's something wrong here. But yes, there's absolutely nothing wrong, whatever. It's the economists who are wrong. That's the thing that's wrong. The real world is that there are many good ideas that seem as good an idea later on as it seemed at the time. Most ideas are like that. We are dealing with a very complicated system where sort of knee-jerk reactions, kind of fast thinking of Danny Kahneman condemns, is being used by courts when they need to have slow thinking. There's not much sign of that in most of the courts.
But ultimately, it's a time-limited monopoly. So if it's non-obvious, if it's novel and it's sufficient, what's the issue?
Yeah. If it works, then it works. You should have a patent for it, even if you haven't really only justified it later. So
crystal clear to me. And does plausibility feature as an issue in non-life science patents at all?
no, not much. In fact, I'm not aware of any case really. And the reason is different for some reason. It's sort of when you have the invention is a mechanical device or an electrical device or something like that, and you describe how it works and you say what it does. I have thought about it as a possibility. Cases where, in effect, the inventor comes up with an idea which ought to be not working according to current states of knowledge. That's because current states of knowledge are wrong. You know, the big fight wasn't the patent case, but the big fight about whether light is particles or waves. Newton said, well, I'll tell you what, they've got to be particles because they don't go around corners. That's why he said it. What he hadn't thought of was waves are so short that they would go around corners. And there was the dispute went on for many years. And there was a famous time when there was a congress of physicists in Paris, I think in about 1880. And somebody said, look, I can tell you it won't work. This was Fresnel rings. He said, if you had two light beams coming through there separately, if they were waves, they would interfere. And that won't happen. So they set it up, and it did happen. Well, patents are not concerned with theoretical physics. They're concerned with the practicalities of things. And if you're taking out a device, depending on diffraction, before people knew that lights were waves, they said it's implausible. But it works. And it's your theory is wrong. And that happens lots of times. So
Okay.
I'm very sympathetic to the, if it works, it's a patent.
And maybe a follow-up question regarding the plausibility. Some people might fear this actually. In your experience, are non-practicing entities an issue in the pharmaceutical sector?
As far as I know, I've never heard of one. I'm not saying even in other issues. Some of them they're not really a big issue in Europe. Part of the problem of the NP is the American litigation system. The idea that an NP can bring a patent action and you buy them off for $5 million because it's cheaper to do that than to win the action is ridiculous. And the sooner they move to loser pays, the better. I know that they said about access to justice and so on, but this is big business because your NPEs are big business too, of a different sort.
Okay. What decision do you think the UK Supreme Court will now reach if they had to decide the evidential standard for plausibility again?
I think they'll change their mind. And the longer it goes on, the more likely they do, because this case will certainly reach the UPC somewhere or other. We know what Galton thinks of it, and we don't think that the other members of the Court of Appeal would disagree. And so suddenly we'll have a patentability in Europe, but not for the UK. We've already got the boards of appeal changing their minds, and it's only because of our doctrine of precedent that it's got to go there at all.
Do you think there's much appetite in the UK though to actually deal with the evidential standard again? Because with the Apixaban case, they actually sought permission to appeal from the UK Supreme Court, and the Supreme Court.
Sometimes they do. Sometimes the reasons why they do that and who did it, I don't know.
Okay.
But if it goes on being like that, it's not unlike the United States Supreme Court. Sometimes they refuse certiorari, as it's called, for a number of cases, and then then they say, right, now it's time to look at it. So it takes a bit of time to do it, but the cases which gets no later on, same point gets a yes.
Okay. And so far, defining and fine-tuning plausibility has been left to the EPO and the national courts. Should legislators intervene by making plausibility an express statutory requirement?
There was a judge in the 1930s who said, reform, aren't things bad enough already? The idea of the legislators dealing with this fills me with despair. Anybody who wants to see how bad it can be should look up the history of the provision of EPC 2000 about equivalence and read the debates. It makes you want to cry. Broadly speaking, what happened was there was a proposal to have a detailed rules about what were equivalents, and they infringed. They couldn't agree. The United Kingdom and Sweden said, "No, look, let's postpone. This needs more debate." Others wanted to push it through, but they couldn't agree on these details. So they said, "All right, you take due account of equivalence," which means absolute nothing. What is due account? You could take it account by saying when we say equivalence infringe, which is what Sumption did in the Supreme Court, or you could say precise opposite. You don't count. You don't include equivalence because they could have, if they could have claimed it and they didn't claim it, then they haven't claimed it. Maybe that would give you a line along the same. Well, if you couldn't have claimed it, then you might have a doctrine of equivalence. But all those were left open.
Okay.
And I suppose
Very good.
one of the beautiful things with the EPC and the patent statutes that are based on it is the fact that the provisions themselves are so thin that they've actually enabled the courts to develop the law based on the technology and the changing commercial
yes, well,
practices.
I think I'm happy to say I think those who drafted the European Patent Convention in its original form did a wonderful job. It's the best patent statute in the world. This area they didn't debate or discuss. Wasn't really live. And compared with the United States, who have real problems, the Supreme Court has not helped it. Quite anti-patent decisions in the last 10 years or so. And my forecast is that China will be a stronger patent country than the United States ere long. They're upping their damages. The quality of the judges is high. Not really for the government to interfere, so there's no question of that. It's just a question of doing good patent law. And we're already seeing also Indian courts waking up and suddenly saying patents matter.
After those bold statements, that would not be possible to do a webinar nowadays without talking about AI, I guess. So here's the AI question. So AI is the hot topic, and particularly in IT, actually. What impact may the use of AI have in terms of a plausibility analysis?
Shall I
Yeah, you
go? There's two. Yeah, you're quite right. It's quite hard to go through an IP related subject at the moment without touching on AI, whether we want to or not. But the two things that can be said on that. The first is the fact that inventing using AI is inherently not going to have wet lab data, so essentially tangible experiments that result in data. So there may hypothetically be more plausibility issues because of it. But the flip side of the coin is also what are we thinking of with the skilled addressee? If the skilled addressee is going to be using AI, then all of a sudden things start to become more plausible and possibly even more obvious.
Yes.
Yeah.
And the second point is the one that concerns me most at the moment is the classical view of obviousness is you have this notional person skilled in the art who's frozen at the date of the time. He has his common general knowledge. He has a piece of prior art, and you ask whether it's obvious in view of that piece of prior art. And then you put that one down, and he forgets it. He picks up another one, and you ask the same question in view in relation to the next one. So that's the classical view. You can only read the two together if there's a pointer from one to the other. AI, every document points to every other document, every document ever published. And suddenly, our whole notion of the person skilled in the art and obviousness has changed. Well, I don't see how one can avoid that, because the real people will also be using AI. So at the moment now, people are using AI for all sorts of research. It's coming up with ideas. It's coming up with better molecules. Whether you then say, well, I don't know whether they work or not, they're implausible. That is on the very cusp of the questions we've just been discussing. You know, AI thinks it might work. Is that good enough? Does that count on one side or the other?
Very good answer. Somebody asked again a follow-up question regarding one of the statements you made earlier. Can you please, will you foresee any other areas where the UK might or will or would deviate from UPC and the EPO position in the future?
I think the UK will be very influenced by the UPC. When its jurisprudence gets established, they've hardly got going yet. But when this kind of thing is established seriously, for example, the Calden view is now the firm view of the UPC. I think there are two questions then. What's the EPO going to do about it? If they may say, well, that's our view anyway, that as Dheemanth has indicated, but supposing it wasn't, that'd be quite difficult. But the UK will follow, I think, the UPC. They're bound to, and industry will do that too. It is the European top court, patent court now.
It just doesn't make commercial sense to diverge.
It doesn't make any commercial sense to diverge.
Okay, very good. And Dheemanth, during your presentation, you briefly suggested that you are not convinced by the need for plausibility to tackle overly broad claims. Could you expand a little bit on this?
Well, what I meant by that was as a separate thing from speculative patent. Let's say they're overly broad claims that aren't necessarily speculative. They, at least in the UK, we're able to deal with that with sufficiency, with a term we have like biogen insufficiency, excessive claim breadth. And our courts have demonstrated that they can take a relatively robust approach using biogen insufficiency in cases such as Regeneron and Kymab, the case to do with antibody production using genetically engineered mice. So if we can deal with that through other means, why do we have to rely on plausibility to tackle overly broad claims?
Anyway, it fits anyway, because you simply say, well, if it's a very broad claim, it is implausible that everything within the claim works. That's not just speculative. That's claiming the whole mountain, not just a small patch of it, and saying, well, there's gold in all of it. And there isn't. It's implausible.
Okay, we still have a few minutes for more questions. So in what circumstances is plausibility a sufficiency issue or an inventive step issue?
Well, it depends on which jurisdiction you look at. Because we've, at least in the UK, we've landed on I'm going to say higher threshold, the positive obligation threshold. It doesn't really matter. But in places like the EPO, they've drawn out a bit more of a distinction when it's going to be a sufficiency issue or an inventive step issue. Where the use has been claimed, the EPO tends to use it to apply a plausibility analysis more under sufficiency. Where the use has not been claimed but has been stated in the description or through other means, then it becomes more an inventive step issue at the EPO.
Yeah, none of it's very logical. One of the things we haven't mentioned, because as I pointed out in my article, there's nothing about plausibility in any of the statute. The route which nobody has taken to justify the result that you can't have a patent is that there is no definition of invention. We know you can't patent an invention which is obvious. What about if it's not an invention at all? And that, I think, is the kind of sort of philosophical logic by saying, well, if you've got no evidence, you simply say, I think this might do that. Have you made an invention at all? Or nobody's ever refused a patent in the EPO on the grounds it's not an invention, doesn't even get into the first box. Doesn't get it doesn't even, it falls at the first step, never mind the first fence. It's not a horse that can enter the race.
I think I think you made that argument before,
Yeah.
as has Dr. Alison Slade in her paper. She says something similar to that.
Yeah.
So please do read those two papers as well if you haven't already.
Yeah, we're going to add the links, the papers directly on the page where the webinar recording will be published later today or tomorrow morning. I think that's time to have the last question, but with two prongs. First is you have a special profile and background, Dheemanth. You studied medicine before, and then you decided to study law. Can you just very quickly explain why?
Very quickly, IP law is the most interesting thing in this world, so why not?
I like it. And if you would like the listeners of the webinar today just to take away one thing from your presentation, what will it be?
Read my paper and the papers that I've cited in this presentation.
Go and do some homework.
Yes, it's pretty much
Thank you so much. I think that's time to get closer to the end of this webinar. I have to say that as for IP, I'd like really to thank you, Dheemanth, for submitting your paper to this research award. It was really appreciated. You know, we received many papers, and I was surprised by the quality of your paper. And so congratulations again, because that's really worth it. And for anyone participating to this webinar that didn't read the paper, please do. You will be, I think, quite amazed the way it is written. And if you intend to submit a paper in the next few years, in the next research awards, I think that will be a good example to follow.
Well, thank you very much. I want to say, I know I've had 2 of my students win your paper prize. I'm aiming for the 3rd as soon as I can.
Please do, please do. And thank you very much, Robin, for sharing your expertise, for accepting to participate to this webinar. I really appreciate it. Your sense of humor is always, adding some spice into the discussion. So thank you very much for this.
One little correction: I no longer sit in the Court of Appeal. I'm not allowed back anymore.
Oh, okay.
75.
I will update the bio then. So for all the attendees, as Dheemanth said earlier, the presentation will be made available on the website. The recording will also be made available later today or tomorrow on the 4IP Council's website. But please do not forget to register for our upcoming webinars, because on the 13th of June, we have a webinar that is entitled The Tailor's Version Strategy, or Re-Recording Music Albums Legally Possible in the EU too. And during this webinar, we'll look at how she did it, and if indeed that would be possible to do it in the European Union. Then on the 26th of June, we do a dedicated webinar on quantum and intellectual property rights with the EPO and 2 European startups that will just explain how they have developed this mindset of innovators, and how patenting, but not only patenting, is very important in the future of quantum in Europe. So please flash the QR code, register to the webinars, and you will receive all the news about this. Finally, I would like to remind you that you should receive tomorrow a short email helping us to, fine-tune the next webinars, asking for your feedback. So please, if you have some time, answer to this email quickly, and that would be really a pleasure. If you want to get in touch directly with me, with 4IP Council, go on the website, you will find all the information. We'll be more than pleased to receive your feedback. So thank you, Dheemanth, and thank you, Sir Robin, for your participation to this webinar today. And I wish you all a great day.
Thank you very much for having us.
Bye.
Bye.